Hello, my name is Iram Khan and I'm here to present on elimination of all forms of discrimination against women. The principles of equality and non-discrimination form the basis of all human rights instruments and cut across all the rights found within human rights treaties, influencing both the interpretation and enjoyment of rights. Yet, women around the world remain one of the most vulnerable sections across religious, caste or class lines. The cycle of discrimination and deprivation against women starts even before she is born. It begins in the womb of her mother and ends only on her deathbed. All her life, she faces prejudice, violence and neglect. Women constitute one half of humanity, yet they have limited access to health, education, and to other denominators of quality of life. Their representation in the political arenas remains limited and restricted still. Various harmful practices like female genital mutilation, dowry deaths, honor killings, child marriages, etc. violate the basic human rights of women. The burning need of the hour is to develop and implement an enduring innovation to ensure the all-round development of women, for only when women will grow to their complete potential can the world at large progress well. Now, coming to the learning outcome. By the end of this module, you should be able to explain about the international conferences on women, list out the major human rights commitments relating to women and the rights provided to women thereunder, especially under Convention on Elimination of All Forms of Discrimination Against Women, India's commitment to the cause of women, and critically analyze the effectiveness of human rights framework with respect to women. Now, history of international conferences on women. When United Nations was born, the struggle for gender equality was in the nascent stage. Even though United Nations Charter mentioned equal rights of men and women and faith in fundamental human rights, only 25 member states out of the 51 original member states gave women equal voting rights and allowed women to hold public offices. At first, under the auspices of Commission on Human Rights, a subcommission on the status of women was instituted in 1946. Later, it received the standing of the Commission on the Status of Women with the purpose to prepare recommendations and reports to the Economic Social Council on promoting women's rights in political, economic, civil, social and educational fields, and to make recommendations on urgent problems requiring immediate attention in the field of women's rights. To bring up the cause of gender equality more vigorously before the international community, United Nations over the period convened some major conferences on women's rights, which are as follows. The First World Conference on Women, Mexico City, 1975. The First World Conference on Women was planned in Mexico City in 1975 to coincide with the International Women's Year. In the wake of Mexico City Conference, the United Nations General Assembly declared 1976 to 1985 as the UN Decade for Women and established a voluntary fund for decade. The increasing momentum around women's issues helped to ensure that the women's perspective was recognized in some of the other world conferences held in 1970s and the UN's various specialized agencies. The United Nations also undertook systemic collection of data on the situation and circumstances of women all over the world. thereby amassing a wealth of new information relevant to women. Second World Conference on Women, Copenhagen, 1980. It was intended as a follow-up meeting to review and appraise the targets set in Mexico City. 145 member states gathered for the mid-decade World Conference of the United Nations for Women in Copenhagen, Denmark. It focused on employment, health, and education. A program of action called for stronger national measures to ensure women's ownership and control of property, as well as improvements in protecting women's rights to inheritance, child custody, and nationality. During the conference, the debates reflected the typical political blocs. The developed countries were more into emphasizing equality between men and women. On the other hand, the developing countries were stressing for social and economic development as having been necessary to improve the status of women. Third World Conference on Women, Nairobi, 1985. The World Conference to review and appraise the achievements of the United Nations Decade for Women, Equality, Development and Peace opened in Nairobi, Kenya in 1985 with a mandate to establish concrete measures to overcome the obstacles for achieving the decade's goal. Governments agreed by consensus to adopt 372-paragraph Nairobi forward-looking strategies for the advancement of women, a blueprint for the future of women development. This conference also saw the transformation of voluntary fund for the United Nations Decade for Women into the United Nations Development Fund for Women. Now coming to Fourth World Conference on Women, Beijing, 1995. The General Assembly decided in 1990 to convene a Fourth World Conference on Women in 1995. This decision was spurred by the UN's growing concern about the uneven pace of implementation of the Nairobi forward-looking strategies for the advancement of women. It marked a significant turning point for the global agenda for gender justice. The Beijing Declaration and the Platform for Action, adopted unanimously by 189 countries, is an agenda for women's empowerment and considered the key global policy documents on gender equality. It sets strategic objectives and actions for the advancement of women under the achievement of gender equality in 12 critical areas of concern, which are: first, the persistent and increasing burden of poverty on women; second, inequalities, inadequacies in and unequal access to education and training; third, inequalities, inadequacies and unequal access to healthcare and related services; fourth, violence against women; fifth, the effects of armed conflict or other kinds of conflict on women, including those living under foreign occupation; sixth, inequality in economic structure and policies in all forms of productive activities and in access to resources; seventh, inequality between men and women in the sharing of power and decision making at all levels; eighth, insufficient mechanism at all levels to promote the advancement of women; ninth, lack of respect for and inadequate promotion and protection of the human rights of women; 10th, stereotyping of women and inequality of women's access to and participation in all communication systems, especially in the media; 11th, gender inequalities in the management of natural resources; 12th, persistent discrimination against and violation of the rights of girl child. A follow-up up to Beijing was seen in 2000, 2005 and 2010. Now coming to major human rights commitments and women. All international human rights treaties and conventions have a common provision with regard to gender-based discrimination being in strict violation of the idea of universality of the human rights. To begin with, the United Nations Charter. The preamble to the United Nations Charter that provide for faith in fundamental human rights, in the dignity and worth of human person, in the equal rights of men and women. Article 1 of the United Nations Charter, laying forth the purposes of United Nations, mentions under Clause 3 to achieve international cooperation in promoting and encouraging respect for human rights and fundamental freedoms for all, without distinction as to race, sex, language, or religion. The Universal Declaration on Human Rights under Article 1 provides, all human beings are born free and equal in dignity and rights. Article 2 of UDHR affirmed that everyone is entitled to all rights and freedoms proclaimed without distinction of any kind, and sex is among the illustrative grounds of prohibited distinction. The International Covenant on Civil and Political Rights and International Covenant on Economic, Social and Cultural Rights. The International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights provide for similar rights under Article 2.1 and Article 2.2 respectively. Both the covenants under Article 3 contain a specific provision recording the undertaking of states parties to ensure the equal rights of men and women to the enjoyment of all rights set forth in the covenant. The Civil and Political Rights Covenant under Article 26 contain a guarantee of equality before the law and equal protection of the law, and in this respect requires that national law prohibit any discrimination and guarantee to all persons equal and effective protection against discrimination on any ground. Some other conventions of concern to women are Convention for Separation of Traffic in Persons and the Exploitation of the Prostitution of Others, International Labour Organization Convention on Equal Remuneration for Men and Women Workers for Work of Equal Value, Convention on the Political Rights of Women, ILO Convention on Discrimination in Respect of Employment and Occupation, UNESCO Convention on International Convention on International Convention Against Discrimination in Education, Convention on Consent to Marriage, Minimum Age of Marriage and Registration of Marriage, ILO Convention concerning Equal Opportunities and Equal Treatment for Men and Women Workers, Workers with Family Responsibilities, Convention on the Rights of Persons with Disability. Now coming to Convention on the Elimination of All Forms of Discrimination against Women. When we analyze the entire human rights regime from the perspective of women, then we find that the most important international human rights convention is the Convention on the Elimination of All Forms of Discrimination against Women. It is popularly referred to as International Bill of Rights for Women. The convention was preceded by Declaration on the Elimination of Discrimination against Women, which was adopted in 1967. The convention comes in as a potent weapon to ensure respect for the principle of gender equality at the global level. The convention was adopted by United Nations General Assembly on 18 December 1979 and it came into force on 3rd September 1981 in accordance with Article 27(1) of CEDAW, after getting ratification from 20 states. As of October 2014, there are 188 countries party to this convention. Some of the salient features of Convention on the Elimination of All Forms of Discrimination Against Women are: firstly, it is an elaborative treaty that covers a vast span of women's rights, including civil, political, economic, and social rights. It tries to strike at the base of the core issue by acknowledging in the preamble to the convention that a change in the traditional role of men as well as the role of women in society and in the family is needed to achieve full equality between men and women. Article 1 CEDA lays out an expansive definition of the term discrimination against women. It states, for the purposes of the present convention, the term discrimination against women shall mean any distinction, exclusion, or restriction made on the basis of sex which has the effect or purpose of impairing or nullifying the recognition, enjoyment, or exercise by women, irrespective of their marital status, or a basis of equality of men and women, of human rights and fundamental freedoms in the political, economic, social, cultural, civil, or any other field. Article 2 of CEDA calls upon states to condemn and eliminate discrimination against women and to undertake various steps in this regard to ensure that the states do not follow any discriminatory practice against women. Article 7 provides civil and political rights to women, including the right to vote, right to participate in policy matters of the government, and right to participate in non-governmental organizations and associations. Article 10, 11, and 12 call upon states to respond appropriately to eliminate discrimination against women in the field of education, employment, and healthcare, respectively. Article 14 looks into the special needs of rural women and entrusts states to secure the application of CEDA to rural areas. Article 15 states that women shall enjoy equality before the law, and any contract or private instrument restricting the legal capacity of women to enter into contract would be null and void. The CEDA has tried to cover the normally left out rights and is all inclusive of economic and social rights which are denied to women in a more likely fashion. Article 5 is an overarching provision that calls upon states to take all appropriate measures to modify the social, cultural. Article 5 is an overarching provision that calls upon states to take all appropriate measures to modify the social and cultural patterns of conduct of men and women with a view to achieving the elimination of prejudices and customary and all other practices which are based on the idea of the inferiority or superiority of either of the sexes or on the stereotyped roles of men and women. Article 16 is yet another attempt to place women on equal footing with men in matters of marriage and family relations. It provides for equal rights to both men and women to enter into marriage and to choose a spouse. Certain particular provisions of Articles 2F, 5 and Article 16 of CEDA Convention deal specifically with the eradication of cultural stereotypes that hamper the advancement of women. CEDA Committee consists of 23 experts of high moral standing and competence nominated by states that have ratified the convention. They hold office for a period of 4 years. These members serve in their individual capacity and not as the representative of the states which nominate them. Now, coming to the procedure of reporting by states. Article 18 of the Convention mandates all state parties to submit a report to the Secretary General of United Nations within 1 year after they have ratified the Convention on the legislative, judicial, administrative or other measures which they have adopted to give effect to the provisions of CEDA and the progress made in that respect. The reports needed to be submitted at least every 4 years or whenever CEDA committee requests the state to submit. The reports may mention about the factors and difficulties affecting the degree of fulfillment of obligations under CEDA. Non-governmental organizations can submit alternative or shadow reports to the CEDA committee with regard to the situation prevailing in their respective countries for a better evaluation of the position of the country. Now coming to recommendations by CEDA committee. Article 21 of CEDA urges CEDA committee to submit its report every year to the General Assembly through the Economic and Social Council about its working and to make suggestions and recommendations after studying the reports and informations received from the state parties. Now, the optional protocol to the Convention on the Elimination of All Forms of Discrimination against Women. In October 1999, the General Assembly endorsed an optional protocol to the Convention. Article 2 of the optional protocol provides CEDA with the mandate to hear petitions and complaints of individual citizens, groups of individuals, and concerned NGOs about violations of the Convention. In practice, this protocol enables women victims of gender discrimination to submit complaints to an international treaty body. The protocol entered into force in December 2000 after 10 states had ratified it. As of October 2014, the protocol has 105 state parties. Prior to the introduction of the optional protocol, there was no mechanism through which individuals could complain to the committee about the violation of their rights under CEDA. Now, we'll discuss India's commitment to the cause of women. India is the signatory to the major human rights instruments pertaining to women, including Convention on the Elimination of All Forms of Discrimination against Women, and is thus bound by the norm of equality and non-discrimination between men and women. India ratified CEDA on 9th July 1993 with 2 declaratory statements and 1 reservation. Article 14, 15 and 16 of the Indian Constitution are worth mentioning with regard to gender equality. Now, we'll discuss some important case laws. In the case of Air India Cabin Crew Association versus Yashaswini Merchant, the Supreme Court of India held that the state is constitutionally obligated to encourage the advancement of women in society, in addition to protect them from negative discrimination. Judges of the Supreme Court have emphasized state obligation towards women in Madhukeshwar versus State of Bihar, saying it was imperative for the state to eliminate obstacles, prohibit all gender-based discriminations as mandated by Article 14 and 15 of the Constitution of India. In the landmark judgment of Vishakha and others versus State of Rajasthan and others, Supreme Court of India held that sexual harassment at workplace is the violation of the fundamental rights of equality and the right to life and liberty under Article 14, 15 and 21 of the Indian Constitution. India, being a party to CEDAW, is required to take all appropriate measures to eliminate the discrimination against women in the field of employment as per Article 11 of CEDAW, and to adopt all necessary measures at the national level aimed at achieving the full realization of the rights in the Convention as per Article 24 of CEDAW. India has made one reservation to Article 29(1) of CEDAW that reads as, with respect to Article 29 of the Convention on the Elimination of all forms of discrimination against women, the Government of the Republic of India declares that it does not consider itself bound by paragraph 1 of this article. Now, basically Article 29(1) of CEDAW provides that any dispute between two or more state parties concerning the interpretation or application of the present convention, which is not settled by negotiation, shall at the request of one of them be submitted for arbitration. Now, we'll discuss the declarations to CEDAW made by India. The two declarations made by India with respect to CEDAW are a hindrance in its goal of gender equality. The first declaration has been made to Article 5A and Article 16(1). These provisions of CEDAW Convention emphasize the government's obligation to eliminate cultural practices and customs that discriminate against women. The Indian government has declared its inability to do so without the consent and initiative of individual communities. The second declaration has been made to Article 16(2). Under this declaration, the Government of India indicates its helplessness to comply with the requirement for compulsory registration of marriages because of the vastness of the country and the existence of illiteracy. Now, we'll have a look into the critical appraisal of human rights framework with respect to women. Why the whole concept of women's human right when we have a full regime of human rights? Why do women require a special mention? Are not women humans? And when they are humans, why do they need a complementary regime of women's rights? Are these women's rights different from human rights? Well, to answer these questions, we'll look into the critical appraisal of human rights. The study of women's rights is not just a study of a catena of rights given to women, but also a way to look into the circumstances and events surrounding them that made them to lag behind by denying equal opportunities and equal access of resources to them. Several feminists describe how the human rights framework failed to look into the needs and aspirations of women. But it is not a recent phenomena, for it is as old as the inception of the modern documents pertaining to human rights which took birth under the United Nations. The first resistance in this regard was seen at the time of the drafting of Universal Declaration of Human Rights, when the Commission on the Status of Women confronted Commission on Human Rights over the referral of the word men to denote humanity and usage of phrase all men are brothers in its first article. Hilary Charlesworth and Christine Chinkin in their article The Gender of Just Cogence writes that although human rights law is regarded as a radical development in international law because of its challenge to that discipline's traditional public-private dichotomy between states and individuals, it has retained the deeper gendered public-private distinction. In the major human rights treaties, rights are defined according to what men fear will happen to them, those harms against which they see guarantees. The primacy traditionally given to the civil and political rights by Western international lawyers and philosophers is directed towards protection for men within their public life, that is, their relationship with government. The same importance has not been generally accorded to economic and social rights which affect life in the private sphere, the world of women, although these rights are addressed to states. A feminist account of international law suggests that we inhabit a world in which men of all nations have used the statist system to establish economic and nationalist priorities to serve male elites while basic human, social and economic needs are not met. In addition, the area of women's rights is a hugely ignored area, despite the fact that there is a rise of gender sensitivity these days. Now, finally, to conclude this presentation, I would like to say that it is to be noted for all times to come that human rights are women's rights and women's rights are human rights. Any change with regard to the position of women in our societies will come from bottom only. All their life, women have no choice but to fight for their half the earth and half the sky. They often suffer from this dilemma whether enjoyment of rights could ever come to them by virtue of they being human alone. The fight seems to be an endless drive to ensure equity and fairness in the world at large. The fight is not between men and women, but it is between the patriarchal attitude and the women's existence. What is your story, women? When will this saga of struggle and pain end? No definite answers, but the quest must go on. Thank you so much.